Thanks everybody for joining us. My name is Ryan Owens. I'm the director of the Thompson Center here at UW-Madison. We're pleased to have a great panel today, some good folks here on the panel, moderating, and in the audience as well. Thanks for being with us. So a few house cleaning things before we begin. First off, as usual, I just want to say a great thank you to both Tia Westhoff and Eric Templis here at the Thompson Center for coordinating, putting this all together. They do a fantastic job here at the center. I want to thank them for their efforts once again. Next, for those of you who are attorneys who are getting CLE credits for this, the presentation has been approved for 1.5 CLE credits. Stick around, listen. Halfway through the event today, we'll give you a passcode, and at the end, we'll give you the second passcode that you can then enter into the Google Forms link found within the chat feature here on Zoom, and that will then allow you to enter the information necessary to get the 1.5 CLE credits. So we have a couple of co-sponsors that we want to thank today. The University of Wisconsin School of Law has co-sponsored this event. The Austin Coffrin School of Business at UW Green Bay is a co-sponsor. We thank them, along with the Lubar School of Business at UW Milwaukee and the UW-Madison School of Business Department of Risk and Insurance. Ty Leverty is here with us today. He is going to be moderating this event. He is an associate professor of risk and insurance and is the Gerald D. Stevens Distinguished Chair in Risk at the University of Wisconsin School of Business. So we're very happy to have Ty with us today to moderate the event. He will be announcing and introducing all of our speakers. So before I kick it over to Ty, I just want to say one thing, and that is one of the things we're trying to do here at the Thompson Center is to bring people together to address and tackle some of Wisconsin's most prominent and profound issues. And I'd say that we definitely have that with this topic today. Now, Teddy Roosevelt used to talk about giving everybody a square deal. And we're in a situation right now where people need a square deal, whether you're a business that has obtained insurance in the past for these kinds of events and you're trying to claim on it, and perhaps you haven't been able to do so, or whether you're an insurance company that has created a business model to insure people in good faith, and now you're faced with potential huge losses from the pandemic. This is an issue that affects everyone. And I think what all of our speakers today want, certainly what we want at the Thompson Center, is to help discuss how we can accomplish a square deal for everyone in this dilemma. So thank you for joining us. I am going to kick it over very briefly to our co-sponsor here, Dick Marcus from the Lubar School of Business at UW-Milwaukee. He'll give a very brief introductory background about his school and what he does at UW-Milwaukee, and then he will kick it over to Ty, who will then get us started. So thanks everybody for joining us, and I look forward to this event.
Oh, thank you. Thank you very much. The Lubar School is very happy to be co-sponsoring this discussion today with the Thompson Center for Public Leadership. Life insurance agents all know how hard it is to get people to think about the unthinkable, the fact that we will eventually die. Behaviorally, we tend to diminish the likelihood of things that we want to put out of our minds. So all sorts of distant things that are unpleasant. So we need this discussion today about low risk of occurring events that have high costs. And I'm happy to be with this. Thank you.
All right, everybody. Thank you for the Thompson Center for putting this together. It's great to see insurance get some attention. We really enjoy talking about it. And an excellent panel. The way that we're going to set this up is that the first speaker is going to introduce business interruption insurance and how it's related to the pandemic. And then what we'll have is a few lawyers go and present different elements of insurance contracts and whether or not they believe COVID-related losses are insurable by existing business interruption policies. And then we're going to turn it over to Tom Baker, who's going to talk about his COVID tracker that's been tracking litigation in this space. And then at the end, we're going to have Lloyd Dixon talk about the future, so ensuring future pandemics with a potential federal plan. So that's sort of what's on tap in the agenda. What we're going to do is allow each panelist about 8 minutes to do introductory remarks. And then we'll have, they'll each have an opportunity to sort of respond to each other. And then we'll turn it over to all the participants to ask their questions. So whenever a question strikes you, please just put it into the chat function, and I will go through those and be able to submit those or query the different panelists about those questions. Okay, so for the first speaker, we are excited to have Shanthi Ramnath, who is a policy economist in the research department at the Federal Reserve Bank of Chicago and a member of the Chicago Fed's insurance initiative. In that role, she works on topics related to insurance and its impact on household decision-making. And so before joining the Federal Reserve, Ramnath was a financial economist in the Office of Tax Analysis at the U.S. Department of the Treasury. So without further ado, I'm going to turn it over to Shanthi.
Thank you, and thank you so much for inviting me to be on this panel. I'm going to share my screen. So I have a couple of slides to give. Okay, so let me just introduce myself. I'm Shanthi Ramnath, and as Ty said, I'm a policy economist in the insurance group at the Chicago Fed. Our group is concerned with topics that affect the insurance industry, and in particular, we're interested in risks that could affect the industry that would then sort of threaten the macroeconomy. And so when the pandemic hit, our first thought was, well, you know, how could this impact insurance? And so, you know, as everyone knows, that state governments mandated closures. The first was in California starting in March. And as a result, we started seeing huge losses that businesses were suffering, particularly among service industry businesses. Some of this was due to the shutdowns themselves. Some of this was due to decrease in demand as people stayed home. And so our concern was thinking about, well, are those losses covered by insurance? And if so, how is this going to impact the industry? And so, like these business owners, we also started looking at property insurance to see whether these losses are covered. And so you might wonder, well, why property insurance? I know I did. So as part of property insurance, there's a piece called business interruption insurance that's often bundled in these sort of multi-peril packages. And what business insurance covers is lost income from and operating expenses if a business is forced to close because of physical damage. So the idea here is that suppose you have a business and there's a fire, and so you're forced to shut down your business in order to do repairs and everything. The business insurance, business interruption insurance would cover that lost income and payroll and whatnot. So this sort of came up as a potential for whether or not, you know, the COVID losses would be covered under this business interruption insurance.
Shanthi, let me just interject real quick. Are you showing your slides and scrolling through them? If so, we're only seeing the title slide, and we're not able to see any ones that follow that.
Okay, let me see if I can do this. Sorry about that. I had it on, okay, can you see it this way when it's?
Yep.
Okay, so I'll just do it that way. I don't know why the view slideshow wasn't working. Okay. Sorry about that. I mean, I'm basically saying what's on the slide.
It's likely it's just going to a different screen if you have multiple monitors, but
okay.
This will work fine.
Okay, great. Okay, so, you know, as I was saying, with the business interruption insurance, it covers this lost income due to physical damage. And the key point there is the fact that the insurance is triggered when there's physical damage. And so in many cases, you know, there's this question of whether or not a virus could be considered physical damage. But besides that, Business insurance also provides coverage for when there's a forced closure. So this is part of the civil authority part of the coverage, and that's due to things like the government shutting down a road because a tree fell and affected another business. And so this came up during the Freddie Gray situation in Baltimore when curfews were imposed because of rioting. And so businesses, restaurants in particular, argued that they suffered losses because of that curfew because it impacted their revenue streams at nighttime when they would be generating a lot of income. And so in both those cases, the idea is that the business interruption insurance could provide protection for those losses if whatever triggered the government shutdown or government closure was due to a covered peril. And in the case of rioting, that's something that property insurance would cover. And so the question then became, well, does business insurance cover pandemic losses? And as I sort of mentioned quickly before, the answer is probably not. So, back when the pandemic, when SARS affected parts of Asia, there was a large case, and I'm not a lawyer, so I'm going to caveat everything I say with that before getting into it. But that where a hotel in Hong Kong was able to get losses from their insurance company because of the shutdowns that were imposed on them due to the pandemic. And so at that time, it became clear that these losses could be large if there were ever another situation that's similar. And so a lot of the property policies were updated to include language that would explicitly exclude losses due to viruses, with the idea being that this is property insurance, it's not necessarily meant to cover that type of peril, and so we need to make that explicit. But for policies without that exclusion, there's still this question of whether or not the coverage would apply, whether or not that virus, whether or not the virus could be constituted as physical damage and therefore trigger the insurance coverage. And so, it was in the news a lot. We saw that there were a lot of, in particular, restaurants who were being denied business interruption claims as a result of COVID because the idea was that the virus was not necessarily considered a physical damage. And so we saw some pretty high profile lawsuits from celebrity chefs like Thomas Keller, who actually started a group called the Business Interruption Group to lobby Congress on behalf of small and mid-sized businesses to get this COVID coverage. And also we know that, I think Tom will be talking about it later, the UPenn has a tracker that actually covers or keeps track of how many of these lawsuits has been occurring. And so as of November 5th, there was about 1,200 lawsuits. So the idea being that business owners believe that if there's no virus exclusion in their policy, they are eligible to receive coverage from their insurance companies for those losses. In addition, state legislatures also have been proposing laws that would potentially force insurers to pay COVID-related losses. And in general, these laws are targeted to paying losses for small and mid-sized businesses. And again, this poses another question of whether or not this is legal and whether this violates some sort of contract clause. So it's unclear whether this legislation would be upheld in courts if it were to be challenged. So thinking through all of these things, what we're interested in is what sort of are the economic implications. And if it's the case that insurers didn't incorporate the risk of pandemics into their pricing and all of a sudden are required to pay COVID losses, then this could lead to some real liquidity insolvency. This could have liquidity insolvency implications. And there has been one trade association, the American Property and Casualty Insurance Association, that released a statement back in April of 2020, that estimated, sort of a back of the envelope estimation, that businesses with fewer than 100 employees were suffering losses somewhere between $255 billion and $431 billion a month. So these are large losses. And if you were to look at what their total sort of capital surplus is to pay off these losses, it's around $800 billion. So a couple of months of payments, and granted, these are sort of seen as more upper bounds, but still a couple of months of payments could deplete, the insurance surplus in assets, and so we could see some potential economic issues as well. So just thinking ahead, as we know that there's this question of whether or not viruses constitute physical damage and whether or not that's going to trigger their insurance coverage. And, as we sort of saw, the ambiguity, especially for policies with no virus exclusion, is going to ultimately sort of push that question to the courts. And so far, there have been a number of rulings, and I just have 2 listed here, but the idea being that the decisions have sort of been split in terms of some judges ruling in favor of the insurers and saying that the virus exclusion and also the virus itself doesn't constitute physical damage. And then there's also been cases on the other side, like this recent case in North Carolina that does argue that viruses are physical damage. So that's sort of the high level overview from a non-lawyer. So with that, I'll conclude.
Great, thank you. That actually was a nice transition piece, because we're going to go into the lawyer section of the panelists. Our first lawyer is Arthur Park. He's a partner in Mosley, Finlayson, and Loggins in Atlanta, Georgia. He practices in the areas of civil litigation defense and insurance coverage. He has authored scholarly articles on consent searches, declaratory judgments, and flood insurance. And he's also taught CLE courses on the Montreal Convention. And most relevant for us is the reasonable expectations of the insured doctrine. And so I will turn it over to Arthur.
All right, thanks, Ty, and good afternoon, everyone. Honored to be here on this panel. Thanks for having me. Just jumping in, before I forget, for more information on all of this, I did write an article. It's called What to Reasonably Expect in the Coming Years from the Reasonable Expectations of the Insured Doctrine. And it was published in the Willamette Law Review back in 2012. So if you want case site, fun stuff like that, that'll be a good place to turn. But for today, just kind of an overview of the doctrine, because it varies wildly from state to state. Some states think it is garbage and give it no credence whatsoever. Other states, you can have a judge do some very interesting things, and he or she can just cite the reasonable expectations of the insured to reach some interesting results. And states treat it differently. A couple of different ways they can do it, which I'll get into. And the reason we're talking about it today with respect to COVID claims is because the reasonable expectations doctrine can be used in certain situations to override very clear policy language. So you might have a policy that very clearly says we exclude virus claims, but in certain situations, the case law might support a finding that the insured still reasonably expected coverage, and weighing all of the policy considerations, public policy considerations, that there still should be coverage in that situation. So kind of understand the doctrine, you have to know where it came from. And it came from a law review article written in 1970 by Professor Robert Keaton, one of the pillars of tort and insurance law. It was called Insurance Law Rights at Variance with Policy Provisions. Very catchy title. And that was written back in 1970. It was in the Harvard Law Review, and everything kind of stems from that article. He made a couple of key points. He says, first, insurance is a contract of adhesion. There's no negotiating between the insured and the insurance company. It's a form that you get, and you're stuck with it. And there's really not that much shopping around. These forms, the insurance companies tend to use the exact same language. Some states require that they use the exact same language in certain situations. So there's not much shopping around. You can't negotiate to pay more money to change this wording. So that really favors the insurance company, not the policyholder. Dr. Keaton went on to say that it's great to read policy. You can try to read your policy, but insurance companies don't always write clear language. They write 100 pages when they could have done it in 10 pages. They use, double negatives. They use legal jargon. They have definition sections that are 10 pages long instead of just using the regular word. They refer to different sections from time to time, and it can be hard for a lawyer to read it, and it can be extremely hard for a regular person to read it and understand what it means and what coverage they actually have or don't have. So again, I can favor the insurance company over the policyholder. Professor Keaton did point out that in his view, it should be an objective standard, not just a subjective, not what do I think about the policy, but what would a reasonable person think about the policy. Dr. Keaton pointed out that most insureds do not read the policy, and he's right. That's still right today, 50 years later. You get your auto policy and you might look at the deck page and see what your limits are, and then you put it in your whatever folder, or it's in your email, and you're not going to sit there and read whether you have coverage if you're operating as an Uber driver on your time off. It's just not something the average person is going to sit there and take out of their day to do. And he finally pointed out that the insurance company can, if they want to, they can bring things to the insured's attention. And they can put things in bold. They can put it on the front of the policy. They can make insureds, initial that they've understood things. And you see this sometimes like in earthquake coverage or flood coverage. It says, you understand that this policy does not cover earthquake and never will cover earthquake under any circumstance. Do you understand that? Initial here, and it's in bold, and it's in all caps, and it's in big letters, things like that. So that's where the reasonable expectations of the insured doctrine started. And from there, each state has taken its own interesting path, and each case is a little bit different. So can't give you an overview of all 50 states right now. Again, the article has a lot of citations if you want to take a look, but kind of picture states treat it 4 different ways. Well, I guess 5. The 5th, one being just get out of here. We don't want to hear what you have to say. We're just going to read the policy, and the policy says what it says. Next, you have the unqualified version, which means they're going to look at anything you put down, what the agent told you, whether you read the policy, whatever the judge wants to think about, they'll take it into consideration. And this has been criticized as basically just judicial rewriting of the policy. The second, or another version, is called the prominence-based version, and that really focuses on where this language was. So in our case, the virus exclusion, where is that in the policy? Is it on the first page? Is it on the 75th page? Is it in the exclusion section? Is it in the coverage, but not covering this section? Is it an endorsement at the very end in fine print at the bottom of the page? That's the focus of that version. Next, we have the ambiguity-based version. And this is very similar to the idea that ambiguous language in the policy has to be construed against the insurance company and in favor of the policyholder, which is called the contra preferentum doctrine, which says the insurance company wrote it. They could write it however they wanted, and if they made it ambiguous, then shame on them. And So this is very closely tied in. The ambiguity-based version is very similar to that idea. And then you have the hybrid version, which kind of picks and chooses. Well, it's ambiguous and it was in fine print in a place that the insured wouldn't have read it there, and so we're going to go like that. And like I mentioned, states are all over the place. I just pulled out 2 from what I could tell of my review. Georgia, where I'm from, is an ambiguity-based version of the doctrine, and Wisconsin, from what I could tell, it looks like is either the whole transaction version or the ambiguity version, depending on which case you cite. So, you know, again, there's not always a clear answer, even in your state. And that's another reason we want to talk about that today, because it's something, each state is a little bit different. And even in your state, it may not be well defined. So it might be worth throwing in your motion or in your complaint that, hey, my state needs, in this situation, we need to tweak the doctrine, or we need to clarify how it works, because I think it covers, it should apply to COVID, or it definitely should not apply to COVID, and also create some interesting appeal issues, which are always nice to have in your case, or you don't want in your case, depending on which side you're on. So we've kind of gone over the reasons, the justifications and support of the doctrine. The only other one I wanted to point out is that a few cases have brought up advertising, talking about how you're in good hands and safe under the umbrella, things like that. And then the insurance company turns around and says, no, we're not going to cover you unless it's these 3 things. The other 97 things are all excluded. Again, that gets kind of subjective and murky pretty quickly. And the doctrine has been criticized quite a bit over 40, 50 years, both in the law journal articles and by certain judges, noting a few things. Number one, that there's a large effect on consumers in the marketplace through increased premiums. So insurance companies generate premiums based on very complex numbers about, we know premiums are going to be this, and we expect the losses are going to be that, so we can charge this and still make money. And when you throw in reasonable expectations, it's very unpredictable. Now you're going to make insurance companies pay for losses that they assumed were excluded because they had an exclusion in the policy. And the only way insurance companies can recoup, they then file bankruptcy, or go insolvent, or they can charge more money next year for everyone across the board. It also results, number 2, a second criticism, now insurance companies are just going to rewrite the coverage and make it even tighter. So anytime someone says this is ambiguous, I don't know what this means, the insurance companies might go back to the drawing board and just really tighten it up, and that could have a bad effect across the board. Third, they call it judicial lawmaking, rewriting policies by a judge on a case-by-case basis. And they also, number 4, complaint is that you already have contract interpretation rules in place that are sufficient, like the contra preferentum doctrine, for ambiguous language, public policy, estoppel, waiver, doctrines that have been fleshed out over hundreds of years of cases, and why come up with some new doctrine to just confuse everybody.
So Arthur, in the interest of time and letting everybody else speak, I'm going to have to cut you off there, but you'll have additional opportunity later on.
That's a good spot.
Oh, nice. Okay. So very nice introduction into the complexity of insurance contracts. The next section of our panel is going to be focused on, initially it was going to be 2 lawyers that took opposing views on whether business interruption insurance policies cover COVID-19 related losses. Unfortunately, one of those presenters wasn't able to join us today, but Linda Kornfeld, who's our next speaker, assures me she's going to be able to present both sides of the argument. Linda Kornfeld is the vice chair of the Insurance Recovery Practice Group at Blank Rome. Linda is a prominent insurance recovery attorney representing corporate policyholders in high-stakes litigation for more than 25 years. She assists her clients in recovery of hundreds of millions of dollars in assets, insurance assets. And so she is the strategic advisor to senior executives and in-house counsel on mitigating risk and maximizing insurance coverage. So Linda, turn it over to you.
Thank you, Ty. Good morning, most of you. Good afternoon to some of you. I will take on both sides of the current battle that's happening between policyholders and their insurers with respect to COVID losses. I will note that Tom Baker, who is scheduled to speak when I'm done, is he's spending a good amount of time these days thinking about these issues as well. And I'd be happy, Tom, for you to join in as I'm speaking to provide thoughts and perspectives, and maybe we can go back and forth a little bit, but I'll start. And what I'll say is that this has become a very significant area of focus for policyholder and insurer side lawyers, given the positions that the insurance industry has taken in response to policyholder efforts to get recovery for the losses that they're suffering. And it's interesting to note that prior to March of this year, if you asked me, in fact, a friend of mine did have this, I had a conversation with a friend of mine in early February about insurance coverage for pandemic and whether there's supposed to be coverage or not for pandemic under business interruption policies. And the view that I had and expressed at the dinner table that night when I had this conversation with my friend have changed significantly as we've spent the past few months really digging into the language in multiple different policy forms issued by different insurers and concluding that there is coverage in many instances. Some instances it's much harder to prove coverage. But at the end of the day, I think the arguments have ultimately become rather sophisticated in just a few short months. This is an area where the law is happening as we're sitting here. You know, every day I wake up and I go to Law 360 and, you know, there's another opinion that's come down in the multitude of lawsuits that have already been filed on COVID business interruption coverage. But let me just step back a little bit and talk about the issues and give a little perspective on how it is that we've ended up with so many lawsuits already filed in just a few short months. But as mentioned earlier, business interruption coverage traditionally applies when you are talking about a fire, a hurricane, a tornado, a flood, some event that causes actual tangible physical damage to a structure. Your warehouse burns down, the roof is blown off of your facility. You know, there's some obvious physical result from an event, and you're talking to the insurance company about your inability to operate your premises and the profits you're losing because you can't operate your premises. And then you have a conversation about your loss and hopefully you get coverage unless there's an applicable exclusion. Here, the debate is all about whether property policies with business interruption coverage included within them were intended to cover lost profits due to a pandemic. And until now, as a result of this pandemic, there was no uniform law out there. In fact, there was no law specific to this kind of event. There are definitely cases out there that were decided in other contexts, which talk about the extent to which you need to show an actual physical alteration to a property in order to trigger your business interruption coverage. There are cases that say that if you've got a noxious fume inside your premises where you do your work, the structure of the premises is the same, but there's some fume that makes it dangerous to work within that environment. Is that sufficient to trigger business interruption coverage? Those types of cases are being considered and argued right now to the courts in an effort to figure out whether there's coverage for these claims. But what I will tell you, and as was mentioned earlier, To the extent that the entire financial consequences of this pandemic that are being suffered by businesses around the world gets laid at the feet of the insurance industry will have a significant financial problem. It just hasn't reserved sufficiently to take full financial responsibility for these claims. And so the insurance industry has responded to the notice that they started getting of these claims, all the way back in March, with a pretty absolute no, we're not going to pay. Traditionally, if you have a fire, you've got a loss, you as a policyholder will work with your broker to give notice to the insurance company and then have a conversation with the insurance company about the claim. The insurance company will request information, the policyholder will provide information, the broker will work with the relationships that they have inside insurance companies to try to get an informal resolution of the claim. Maybe coverage counsel will get involved to talk about and negotiate on tricky issues, but generally speaking, these relationships come together most typically to resolve a claim informally. Those relationships and that process is not what's happening here, because the insurance industry has decided that they can't say yes to anyone without a court or an appellate court ultimately telling them that they have to, without opening the door and the floodgates to have this financial repercussion. And so brokers have tried to work with their relationships, behind the scenes with insurance companies. And the answer has been no. Insurance companies are requesting information from policyholders. Lots of detailed information is being requested. But from our experience speaking to many colleagues and clients, no matter what you say in response to these requests for information, ultimately you're getting a denial. And so for policyholders who are, feeling bullish about their claim, really at this moment in time, until there are more court decisions and at the appellate levels, we're not going to have insurers agreeing to coverage without actual filing of a lawsuit. And I just wanted to speak really quickly about the language that we're dealing with and what policyholders should be thinking about in deciding whether they want to aggressively pursue their claim. The first issue with this coverage is whether you actually trigger the business interruption coverage under the policy. Language in insurance policies is everything. As we just discussed, the reasonable expectations of the insured and how that concept plays out. The first place you always look in an insurance policy is at the language. And most policies have some language along the lines of you need direct physical loss of or damage to covered property in order to trigger the policy. Some policies say they cover all risks of loss of or damage to property, and that triggers the policy. Whether you've got the quote unquote all risks of language or the all risk language is not included in your policy, actually in these cases can be pretty critical. The all risks language may allow for a lower standard to trigger the policy. The insurance industry is really focused on the damage to property piece of the trigger language, but in many instances, they're trying to sort of combine loss of and damage to into one concept and treat them as if they're the same. You need physical damage to your property, but they're not the same. And the cases that have ruled thus far favorably for policyholders are focusing in on the loss of language. You don't need to show an alteration, a physical alteration to your property to get coverage. The arguments that we're making and some courts are accepting so far, and we expect more courts to accept as we continue down this road, is that loss of use of your property because of a very significant threat of spread of COVID, should you be operating your property as normal, is sufficient to trigger the policy. And if you can trigger the policy, then the question is whether you've got any language in the policy where if the word virus is contained anywhere in your policy. And we thought initially this would be the debate in the courts. The debate in the courts really has focused so far on the trigger question, but we will soon be advancing into this virus question. We've reviewed hundreds and hundreds of policies since March, policy forms, to try to get a sense of who's got the good language and who's got the less favorable language. And I would say with respect to the quote unquote virus language or a virus type exclusion, you know, there's a significant percentage of policies that have a quote unquote virus exclusion or something even more explicit with respect to coverage for pandemic. There are some policies with an infectious disease exclusion. There are some policies with a pandemic exclusion. Certainly as we are going forward and insurers are renewing coverage for the 2021 policy year, they are adding much more specific language with respect to pandemic. But a lot of these policies that were issued before the pandemic started may include the word virus inside a pollution exclusion. That exclusion will talk about things that would traditionally be considered a pollutant, and then throw virus into that string of words and then say, hey, in response to a COVID claim, we have a virus exclusion. That is not a virus exclusion. You got to look at the words in context, and we feel very strongly that if the word virus is sitting in a traditional pollution exclusion, it's going to be hard for the insurance industry to rely on that and avoid coverage, particularly because there was a virus exclusion created after SARS. The insurance industry in 2006 created a bacteria and virus exclusion that, at least behind the scenes and talking about the drafting and providing it to the insurance industry, there was some commentary about this was the response to SARS. This is intended to help insurers should there be a pandemic. And that language has been available for use by the insurance industry since 2006. If you have a policy that does not have that exclusion, it may have virus language, like I said, in a pollution exclusion or somewhere else in the policy, but does not have this 2006 insurance industry language in the policy. That's a pretty good argument that they knew how to protect themselves from pandemic or virus, a contagious disease like this, and they decided not to. With respect to the virus exclusion, if you've got it in your policy, there's certainly a number of cases that have been filed where that exclusion is in the policy and the policyholders are arguing that it doesn't apply, and we'll see how that battle turns out. But at the end of the day, again, the language matters. It may be also that you yourself, your property has been open and was open this entire time, but you have no one coming to your property because your business, let's say you're a McDonald's or some other fast food drive-through business that people traditionally drive through on their way to work or on their way home from work, and all the office buildings right next to them have been closed and nobody's been driving through, even though they were open. There's something called attraction properties, attraction coverage, where you lose business because you are next to something, a business that usually drives business your way. I think a really good example of that would be a university. There are a number of businesses that operate on campus or around campus at all the universities, because those universities were closed. Those businesses had no traffic at all. It's the university that drives the business for these properties, and they're not making any money because of the event. So I would definitely advise policyholders to take a look and see if you have attraction property coverage under your policy, to see if that may be an alternative approach if you've been open this whole time. But again, the words matter, and if your insurer has said to you no coverage, I would say that if your losses are significant, it's important to get some good advice, a very deep dive into your policy language to combat what the insurers are saying, because no matter really what your language is, and even if you don't have a virus exclusion at all, those claims are still being denied. But just because the insurance industry is denying doesn't mean that they're right. Tom, I don't know if you have any thoughts to add. You're on mute.
So I think you covered it very nicely, and I'm just going to give a little picture of what the litigation looks like. So I'm going to share my screen.
Tom, let me first introduce you for everybody.
Okay, sure.
Off, thank you, Linda. That was great. Our next presenter is Tom Baker. Tom Baker is the William Mall Measley Professor at the University of Pennsylvania, where he is on the faculty at the Carey Law School and the Wharton School of Business. His COVID coverage litigation tracker is the definitive source of information about COVID-related insurance litigation. And Tom does a lot of research in the insurance space and he's going to provide us some idea of how courts are interpreting these policies. Tom?
Okay, so great. Well, thank you. So we very early in the pandemic, it was clear to me that there were going to be a lot of lawsuits, because as the reason that Linda said is the insurance industry literally couldn't afford to pay them, kind of whether they were going to be covered or not. And so I viewed, so I wanted to keep track of them, both as a public service and as a way of me dealing with my anxiety related to COVID. And then third, I think we're going to be able to use these data for some interesting examination of the civil justice system. And for the researchers that are on this call, if anyone has any ideas about how to use the data and wants to know more about it, just be in touch with me. I'm easy to find. So here's just a picture of the weekly filings. You can see that there's been a significant decline, but there was a lot of filings. And right now, as I think Shanthi said, we have north of 1,200 cases in our database, and I've just actually posted a blog post yesterday explaining how I have an estimate for the total number of state cases, because although we think we've got all the federal cases, we know we don't have the state cases, and we think that we're missing close to 400 state cases that are out there. And so we think there's more like about 1,700 of these lawsuits, most of which are business incomes. This is a picture, we're coding the cases based on what the policy, what they're about. And business income, extra expense, civil authority, sue and labor, ingress, egress, all of those are basically the kind of business interruption property coverage things that we've been talking about so far. There's a significant number of suits where there's coverage explicitly for contamination, some suits about cancellation, and many of those are class actions. And then a number of lawsuits in which policyholders are seeking premium relief, as I'm sure most of the people on the webinar are aware of, that especially auto insurance companies, but also even some homeowners insurance companies gave some premium relief because their losses went way down. And these are lawsuits saying that they didn't do enough. We're coding the cases by the industry. And these are the top ones. It's nothing surprising, right? It's what food and drinking places, ambulatory healthcare services. The biggest there would be dentist offices, believe it or not. But the list goes down. It's really it's the economy of people who couldn't work remotely, essentially, is who's bringing these lawsuits. And one thing to note is that the number of lawsuits, that's an extraordinary number of lawsuits, of business interruption lawsuits, but it's really just the tip of the iceberg of the potential exposure. That there are, for every lawyer like Linda or the lawyers who are bringing these cases, they've got 20, 30, maybe even 100 clients who are basically sitting and waiting to see how things go. Here's an interesting chart that we created that charts the number of cases filed in a state according, litigation cases, lawsuits, by the COVID-19 cases in the state. And the sort of mass at the lower left-hand corner tells you that there's basically a pretty expected relationship, more COVID cases, more COVID litigation, with some outliers here. And one of the things that we're going to be doing is trying to figure out kind of why are more cases being filed in some jurisdictions than others. There's an easy answer for Pennsylvania and Illinois, which was there was a big effort to try to do a national multi-district litigation. And there were teams of lawyers that were advocating for the cases to be consolidated or coordinated in Pennsylvania, another team coordinated in Illinois. And one of the ways you compete in this kind of race is to have more cases filed in the given jurisdiction to show that that's the center of gravity. So that's just interesting. One of the things that we have done that is actually remarkably hard to do is we've grouped the cases according to the parent insurance group, because your Lexis, your Westlaw, even your Lex Machina, your Bloomberg, they they record cases according to the insurance defendant. And insurance groups, Hartford's Financial Services Group, which is leading the pack here, the most frequent company in the Hartford group that gets sued is Sentinel. And if you saw Sentinel Insurance, you'd have no idea that it was part of Hartford Financial Services Group. So this shows you just a picture, a couple observations for building about these individual companies based on some of the things that Linda has said is the Hartford Financial Services Group. One of the things we're looking at is how often, how regularly do the groups put virus exclusions in their policies as measured by the sample that we have, which is litigated cases. And the thing to keep in mind is, because having a virus exclusion in the policy is not a good thing for a policyholder, we think on average, the lawsuits are going to be biased in favor of policies without virus exclusion. So we don't think that our lawsuits is, the lawsuits are a good measure of what's the world out there outside of a lawsuit. But still interesting about the lawsuits. And the Hartford Financial Services Group basically almost always had a virus exclusion, but it was their own unique virus exclusion that was drafted earlier than the ISO one that Linda talked about, and that got put into the policy in connection with problems to do with mold. And so that is something that lawyers like Linda are going to be emphasizing quite a bit when they talk about Hartford. Cincinnati has chose not to use virus exclusions. And so, that makes, and the, my back of the envelope analysis of what happened in the stock market comparing Hartford and Cincinnati is that my impression is that Cincinnati's been a bit more punished by investors in the COVID than Hartford. The rest of the groups here are sort of more mixed. Travelers pretty much always use the ISO. Underwriters at Lloyd's, Lloyd's is a market, it's not an insurance company. And so we've grouped all the cases involving Lloyd syndicates, but they don't all operate the same. So there's a bit of a mix. Erie is a company that sold some policies with exclusions, some policies without exclusions. My impression is more often without, but that may be a function of just who's filed lawsuits. Society, another insurance company that didn't use virus exclusions. And so, one thing that I see here is that, in what puts groups at the top of the litigation list is both sort of overall exposure, namely, did they sell insurance into these frequent industries, but also, what were their practices in regard to their insurance policies. And so that will be interesting to follow up. This is as of this morning, this is the box score on what we're calling the merits rulings on motions to dismiss. This is when a judge decides to grant a motion to dismiss, which would be filed by an insurance company, which would make the case go away, or to deny a motion to dismiss, which allows the case to continue on. And a grant would be in favor of the insurance company, a denial would be in favor of the policyholder. And what we've seen here is that on the whole, there's been more granting of the motion to dismiss than denial. And that's the big, the picture at the top is the picture that the insurance industry wants people to know about. The picture that I want people to know about is in the little box score at the bottom. That when there is not a virus exclusion in the policy, the policyholders are ahead narrowly. And I will say this, that, and I hope that people listening, lawyers listening to this, don't take this in the wrong way. But we've yet to really see the A-team litigating these cases. It's not, in other words, people like Linda, who've been doing this for 30 years and really know that what you have to do is to dive deep into the specific language of the policy, deep into the specific practices of the insurance company in order to make your best argument. And I just saw about, an amicus brief that Covington and Burling filed in what will be, I think, the first appellate decision in the district court and the Superior Court in DC. And it was really, it was a step up from what I've been seeing in relation to most of the motion to dismiss briefing. So I think, it's very early days. I think there's a lot of exposure. And another thing that we're doing that we're going to be announcing next week is we are identifying the cases in which there's at least one insurance company that answered, but did not file a motion to dismiss. Because that is the equivalent from a kind of survival of the case to a policyholder winning a motion to dismiss. And I think when we announce those numbers, that's going to have an impact and a bit maybe change the narrative a bit about what's happening with these cases, because there are a lot of cases in which insurance companies are filing answers and not filing motions to dismiss. We've been coding that, you know, we're not 100% confident. We keep changing our mind a little bit, kind of how to code some of these in virus exclusions, because the more you read policies and read them again and again and again, you understand them differently. But, you know, a lot of cases don't have in our have no, you know, if we say there's not a virus exclusion, we're confident about it. But we put the virus exclusions into different buckets here. And so the explicit virus exclusion without an anti-concurrent causation provision, that would be the kind of ISO standard. That, you know, more than that fits in this category. There's the hidden virus exclusion that, you know, Linda talked about. There are, you know, Travelers, State Farm, some other companies have, you know, what I call the high test virus exclusion. There's an explicit virus exclusion. It says it's about communicable disease. And there's this thing called anti-concurrent causation provision, which is deep into the insurance law weeds, but very important. And then there's a bunch of policies that have some specific coverage for communicable disease. And so, you know, so it's, you know, it's not a one size fits all situation. Here, yeah, sure.
Can I just quickly mention something about the policies that have explicit communicable disease coverage?
Yes.
You know, the insurance industry is arguing, and I think Factor Mutual is one of the insurers that's making this argument most loudly, is that, and they have in most of their policies, they've got a small sublimit for quote unquote communicable disease coverage, but yes, they don't have a matching exclusion for communicable disease. And they're saying basically, yes, we jumped in and we agreed to provide communicable disease coverage. Read that provision in our policy where we have it, and you get $500,000 of coverage, and we're done. And some policyholders are agreeing with or buying into that argument. And I think the other side of that argument is actually that's really narrow coverage, and the broader business interruption coverage for pandemic falls outside of that coverage, and there's no exclusion. And so you're entitled to the full policy limits as opposed to just a narrow limit for.
Yeah, I mean, it's interesting. I haven't studied that particular clause carefully. I know that that's a common structure for flood sublimits, and that those sublimits tend to stick, so to speak. And so the question would be, is there something that's different about the communicable disease coverage? I agree with that. So let me just wrap up until we get into data. I want to tell people what the data are that we're collecting, so that people know what we have, because it's not all kind of visible from the website. And the website is just cclt.law.upenn.edu, or if you just type in Corona Coverage Litigation Tracker, you'll get it. Or you can just type me, Tom Baker Insurance, and get to my webpage and then click on the link there. But we're basically, you know, we start with data you can get from a lot of other places. And what we're doing with that is basically, you know, what I really think of as kind of data engineering, which is that we're pulling it all together, normalizing and identifying the important things, following them across courts and electronic services. Like when a case gets remanded to state court, we continue to follow it. If it gets removed to federal court, we continue to follow it. We code the data uniformly, which is not the case by you know, courts and, you know, PACER, and even to some extent Lex Machina and other more high-powered people who, you know, repackage PACER data. You know, much of their data is unstructured, whereas, you know, we're turning into structured data, and then we are hand coding a variety of things that are literally not captured anywhere else. And we're, you know, eager to hear from researchers about what would be good questions to answer for this, and you know, and we're, you know, eager to hear from lawyers of, you know, how can we make this useful for you in the sort of near term. I mean, you know, the ultimate goal of this is to serve as knowledge for research about the civil justice system and insurance litigation, but the near term is we'd like to be useful to people like Linda and others, people who are engaged in the litigation. So with that, I think I'll stop so that we can move on.
Great, thank you, Tom. That was very interesting. Our last speaker is Lloyd Dixon, but I want to hold off here since we're sort of at the exact halfway point. I want to make sure those folks that are participating, they're able to get their CLE credit. So Part 1 of the passcode is Thanksgiving. Let me repeat that. Part 1 of the passcode for CLE credit is Thanksgiving. So last time to jot it down, Thanksgiving is the Part 1 passcode. Okay, so our final speaker is going to sort of change directions a little bit. Lloyd Dixon is the director of the RAND Center for Catastrophic Risk Management and Compensation and a senior economist at the RAND Corporation. He has expertise in insurance, compensation, and liability issues. Recent studies of Lloyd's have included the effect of wildfire risk on California's residential insurance market, the costs and affordability of flood insurance, and early assistance from potentially responsible parties for human-caused disasters. And Lloyd will be discussing potential designs for a future pandemic risk and insurance program.
Great, thank you, Ty. Let me just see if I can share my screen here. Okay. All right, I think that should work. Okay, great. Pleasure to be here with you all this afternoon. And I'm going to talk about some key questions to ask in designing a pandemic risk and insurance program. So, so far we've talked about existing policies and litigation and coverage issues with existing policies. And so I'm looking more next steps, assuming the insurance industry will try to exclude coverage for virus or pandemic risk moving forward. Unless something happens, what are some possible or some policy options for addressing that? So first, we think of just sort of background, when we had the 9/11 attacks, at that time, terrorism coverage was typically included, and or coverage for a terrorism event was typically not excluded from an insurance policy. Once 9/11 happened, insurers began to exclude coverage for terrorism, and there was a lot of concern about the economic impacts of that. And one of the consequences was the Congress adopted the Terrorism Risk Insurance Act, which was kind of a public-private partnership between the insurers and the federal government to share terrorism risk to make that coverage more available. So, in effect, we're sort of talking about something similar here. And I'll talk a little bit more about this in a second, but assuming insurers really don't want to cover this kind of risk. It's very difficult for insurers to cover this for a number of reasons, pandemic risk, that if they're going to provide, if there's going to be a market for coverage, there's going to need to be some kind of public-private partnership. So in setting up that, or in deciding how to proceed on that, I think it's useful to first start with, what's the goal, or what are you trying to do with that kind of policy? Well, first it's to, the overarching policy goal, I think, is to establish some kind of risk transfer mechanism or financial protections for, businesses or firms for epidemic infectious diseases. And the goal of such a mechanism would be to enable businesses to obtain loans at favorable rates, address their liability risk, keep key personnel employed during shutdowns. It would also serve larger social goals, like maintaining payroll of the workforce. And, just wanted to point out that a lot of business, my understanding is a lot of business interruption policies will apply to, key personnel and the cost of maintaining key personnel at a firm, but not necessarily all employees, because firms can lay off those employees. So, you may want this kind of program to serve these larger social goals of allowing firms to keep their entire workforce employed and dampen a downward economic spiral. So there are, two different approaches for doing this. There may be others, but two you could think of. Well, we could have some kind of government-run program. We had the current pandemic. We had the payroll protection program that provided assistance to firms. There's discussion now about legislation related to a liability shield that would shield businesses from liability or cases by their customers or employees related to exposure to COVID. On the other hand, you can take an insurance mechanism approach, and that would be using business expense policies that would include payroll, the types of policies we've been talking about this morning. You could have, that would include liability policies, insurance policies that firms could buy. And, doing this, using this insurance mechanism would allow us as a society more generally to take advantage of the insurance underwriting and claim payment infrastructure. Instead of Congress passing a law and a program and having to come up with a whole mechanism for distributing those funds, we could take advantage of the insurance claim paying mechanisms. Now, there's definite benefits of going with an insurance mechanisms. First, I think important, a major benefit is it sets benefits in advance rather than relying on the government to craft programs on the fly after an event. Relying on the insurance, as I just said, relying on the insurance mechanism allows us to use the existing claim paying infrastructure of insurers. It can leverage insurer expertise and risk mitigation, and potentially transfer some of the pandemic risk to the private sector, as opposed to just expecting the public sector, the federal government in particular, to cover those losses and the taxpayers. Now, on the other hand, the drawbacks of this kind of approach are that the amount of risk insurers are willing to take on appears small for pandemic risks. It's not a risk they want to pick up. You can have a program like this, but there may be potentially low take-up rate that businesses might not buy the coverage. You have difficulty in determining what the appropriate rate should be. We don't have a well-developed, historical record on how often pandemics are expected to occur. And then there's also the coverage litigation that can result. So, what we've done it's a blog up on our website is examine some of the key questions to ask in designing such a program. If you want to proceed with the insurance approach and the insurance mechanisms, and you're thinking of designing a TRIA type program, or a program that has a public-private partnership, what are some of the key questions to ask in that process? So here's some examples of first, how much risk should the private sector bear? Should the government charge a premium for the risk it bears? Currently, the TRIA program, I'll explain that, the government doesn't charge a premium. Should businesses be required to purchase the coverage? And should the program be bifurcated by firm size? Should you have sort of different options for large versus small firms? So I think today I have time maybe just to go through a couple of these, which I'll do. And just give you an example, some sense of the kind of policy, discussion that is involved around each of these different questions. So the first one, how much risk should the private sector bear? So what's our policy objective here? Well, what you're trying to do is move some of the risk to the private sector and give insurers, in part, give insurers incentives to carefully underwrite and adjust claims. So in other words, if the federal government has all the risk, like in the federal flood insurance program, for example, it does bring questions of what incentives insurers have to carefully underwrite and adjust claims. So on the right side of this chart is a little example of what some of the programs have done. So there's a number of proposals that are out there now for these types of programs. One's called the Business Continuity Protection Program. Another is called CREA, which is modeled after the TRIA program, Pandemic Risk Insurance Act. That's been introduced by Congresswoman Maloney. And then an example, the Chubb has a proposal they've introduced for SME, small and medium-sized enterprises. And in all three of these, you can see there that there's really a modest risk bearing by the private market, and that just reflects the difficulty in of the private sector picking up this coverage. So in the BCCP, there's no private sector retention of the risk. In PREA, the insurers pay 5% of claims costs up over a deductible up to a cap. And some, and so in thinking about this, some of the considerations are, you might say, well, if the insurers are only paying 5%, is there really a point of having this program in the first place? Why go through all the trouble of setting up a public-private partnership when the private sector is really bearing a small amount of the risk? But the counter to that is that this giving insurers some skin in the game aligns insurer and government incentives, and it could be that in the future, if the government becomes better at containing these pandemics to regional areas, or these pandemics, but maybe the amount of private sector risk really would be substantial. So let me do one more, I think, in the time that I have, and that is, should the government charge a premium for the risk it bears? So currently, the TRIA program, the Terrorism Risk Insurance Act, the government does not charge the insurers for any risk that the government's picking up for those policies. And the policy objective here is to impose program costs on those who benefit and reduce moral hazard and accumulate funds for future claims. You see the three different programs there. In one case, there's no, in a PRIA program, there's again no charge for the federal share. In the Chubb program, there's no charge for the federal share. And the BCCPP is, doesn't talk about it extensively, but their pricing is, let's set the prices so businesses will buy the coverage, so set them low enough so that it's attractive to businesses to buy the coverage. And I think, one of the considerations here, some of the considerations here are that first, you can't expect businesses to pay the full cost of this insurance because there's, as I talked about earlier, there's some social goals here of having their whole payroll covered as opposed to just their, key, firm capital or people with firm capital. Second, likewise, the government also benefits from this. So, perhaps that, that argue that there's no need for the government to be charging their full premium. On the other side, the premium revenue may cover costs for some smaller events that, would shift some of the costs to that offset some of the government costs. And that if you have some premiums, they provide some meaningful opportunity for rate reductions for risk mitigation programs. So if you have some premium, that argues that, firms maybe be able to get a discount if they do certain mitigation actions, which gives them incentives to be more careful. So I think I'll stop there and just conclude, with the way we think about it. So thinking about each of these these questions, these kinds of questions, helps you put together the pieces of a risk transfer mechanisms. And I think it's important. This last bullet there, this debate over pandemic risk insurance provides an opportunity to better understand how the insurance mechanism can remain part of the U.S. strategy. We don't want to see the insurers, the industry walk away from all the significant risks facing the country. And so I think it's important to have this discussion of how can the insurance industry be involved here. All right, so that's I think I'll stop there.
All right, great. Thank you, Lloyd. So I think the first thing we'll do is give each of the panelists an opportunity to respond to anything that they heard or to raise questions to the other panelists. No particular order, but if you have a question or you wanted to query one of the other panelists, it's a time to jump in. And while you're thinking about that, I want to encourage participants to ask questions for the panelists and put them in the Q&A function down at the bottom, and I will read those. So any panelists want to? Tom, I see.
So I have a question I guess it's for Lloyd and Shanthi, which is, I'm wondering what you all think about the role of the current coverage litigation in the larger political discussion around what we should do about pandemic losses. In other words, is there a reason to believe that the insurance industry losing a few of these, starting to feel the pain, starting to feel the risk that this might actually be something that they will be responsible for as a way of kind of getting them to the table to be kind of more active participants and reasonable participants in arriving at a legislative solution?
Yeah, I could start. Shanthi, you're on mute still, but I can start there. So I think the insurers really are very interested in the kind of programs I'm talking about. That the insurers realize that it doesn't look good for them to have to tell their policyholders that something's not covered, right? And coming up with a system and something that will work for them, that allows that coverage to be provided, is something they're very, very interested in. And I think certainly the coverage litigation increases the stakes involved in that. But I do think that there's in the same way that the insurance industry was very supportive of TRIA. And, and there's different parts of the insurance industry. There's primary insurers and reinsurers, and there's variation on the attitudes of different parts of the industry to these programs. But in the case of TRIA, there was a pretty widespread support for that program. And from what I'm seeing, there's different approaches and different angles from the insurance industry how best to do that. But that there is real interest in seeing something happen.
Yeah, I mean, I would just echo what Lloyd was saying, that it raises the stakes. And so I think that they would have an incentive to try to form some sort of partnership if they're found to be liable for those losses. So.
Yeah. One question I had that, I'm sure it's a little bit of a rabbit hole, but the sort of anti-concurrent causation, something be useful to, if someone would just, I'm always confused by that. If someone would, what's the issue here? How does that
Here,
work?
Linda, I'll do this because I teach law students about this every single year. So that, causation is, we all think we understand causation, like X cause Y. I mean, as a social scientist, we know how hard it is to be kind of confident from an evidentiary perspective, but in a common sense way, we think that we understand causation. But it turns out that things always have multiple causes. I mean, the joke I tell my students is, my mother caused everything that I ever did, because if she wasn't here, I wouldn't be here. And so there's an effort to and so the courts have struggled with this, because especially when you think about in the origins of property insurance, it was not the kind of all risk insurance that we have now. It was a named peril insurance. And so it would be frequently the case that there would be a loss in which a named peril played a part, but something else was involved. And so courts struggled to get to the question of, well, okay, what's the cause that matters? And so they developed a doctrine that went by the name of just concurrent causation. If there can, as long as you're one of the concurrent causes, you're going to be responsible. And so the insurance industry wrote insurance policy provisions against that to try to get around this sort of concurrent causation doctrine. And those are called anti-concurrent causation provisions. And so different insurance policies have different amounts of anti-concurrent causation language in them. And the ISO virus exclusion does not have the anti-concurrent causation language in it. Now, to go even further down the rabbit hole, there's a few states that say, listen, the rule of that we're going to try to find the most important causation, the efficient proximate cause is the not very delicious term that they use for this, is that there are some states that say that the rule that you have to pay if a covered cause of loss is the efficient proximate cause, that is a rule that in some states you're not allowed to contract around. And arguably, the state of Washington, possibly California, there's some states that say that the efficient proximate cause rule is a mandatory rule, meaning that we're not going to give effect to anti-concurrent causation language. So that's what that's about. And so, for instance, someone could say, "Hey, the viruses didn't cause my, bar to have to shut down. The government order caused my bar to have to shut down. And if the business can convince a court that loss of the use of the bar meets that physical loss of requirement that Linda talked about, then they might be able to recover, notwithstanding the virus exclusion, in a if either there was not an anti-concurrent causation provision in the policy, or they were in a jurisdiction in which the efficient proximate cause rule was a rule that applied even if you tried to have that anti-concurrent causation language." I don't know. That's probably not very. It's like you said it's down the rabbit hole. It's totally down the rabbit hole.
No, that helps.
Yeah, Tom, thank you for taking it. You did a great job. I was making my head hurt already just trying to think how was I gonna do it. So good job.
There is some benefit of teaching, young law students on a yearly basis.
You took what is usually sounds like we're talking a foreign language and put it into the English language in a very clear way. Thank you.
Well, thank you. Thank you.
So sort of along the same lines of thinking about language, you had mentioned that the policies that you were looking at, Linda, you were looking for sort of that good language. And so I was wondering, is there any sense for which smaller businesses are less likely to have sort of the good language policies, or as larger businesses are going to have that? So could we see something where, you know, it turns out that there's going to be losses paid out to larger businesses just because they tend to have better coverage? Or it's just in general data on individual, sort of like the micro level data is difficult to find. So we don't really have a sense of heterogeneity across these different policies. So I don't know if you had a sense of that.
I will comment, and then Tom, I'm sure you have some strong information on that. But what we certainly with really large businesses, it's more manuscript, right? And you have towers of insurance and different participating insurers, and you do see, differences in the language there. For certain industries, you'll see, one insurer and their form more prevalently, so in the hotel industry, at the smaller levels, you may see the Zurich Edge form. In smaller businesses, you often will see a Hartford form, Travelers, and you also, Cincinnati has insured a number of the smaller businesses, and the Travelers form has a very strict version of the virus exclusion, and includes the anti-concurrent causation language with respect to that exclusion there, whereas Cincinnati doesn't have an exclusion at all. But I would say that everybody going into the market is going to be presented with many less options. And as small businesses, the ability to get out of what will be very strong pandemic exclusions will be hard.
Yeah, Shanthi, I would, I described it as a kind of reasonably informed intuition, is that it's really quite random. Like, someone didn't end up with a Cincinnati form because Cincinnati doesn't have the virus exclusion. Someone ended up with Cincinnati because they were in the kind of business that Cincinnati marketed, or their friend was a broker who worked with Cincinnati. Same thing with Society Mutual or Erie, which is another company that, frequently didn't use virus exclusion. And, the Hartford, I'm sure right now they're wishing that they had switched to the ISO form in 2005, but, that's really pretty random. They had a virus exclusion. Why did that was already theirs? Why did they need a new one? It would be sort of a reasonable decision that they would make at the time. And, Travelers, they put it in their form. Who knows why they did that? State Farm has a really strong one too. Now, State Farm, is, in my view, tends to have the most restrictive coverage really in any market they're in. No offense, State Farm, but and it's because they have enough market share. They don't need to use the same forms as everyone else because they don't need anyone else's data, so they do their own thing. But I really, except for the people who were big enough to buy from FM Global, which had this covered the sub limit, but even that, if the sub limit isn't very much, so nobody really had a lot of explicitly agreed in advance. Everyone knows it's pandemic coverage, and so what people's situation is it's pretty stochastic. It's not the result of choice.
Thank you.
Just to pile on a little bit, if we are seeing insurance companies rewriting the policies behind behind the scenes right now for everyone who's going to renew in the fall or in 2021, it'll be interesting to see from the reasonable expectations lens, are they going to put it in giant letters in bold on the first page? This policy, excludes virus claims, initial here that you understand this, or is it just going to be rewritten as an exclusion on page 75 of the policy, and it is what it is.
Thank you all.
So open it up to some questions that we've been receiving in the Q&A tool here. One is sort of related to what Arthur just pointed out. Insurance companies will be changing their contracts. And so this is a big picture question. Is pandemic risk insurable? Do you think that the private industry can take on this type of risk?
Yes, Lloyd. Yeah, I think it's very difficult for the private insurers to take this on. This type of risk doesn't. There's criteria of the risks that are more amenable to being insured, and pandemic risk does not fit that very well. It has large losses that large sets of policyholders can be affected at the same time, so you're not able to diversify your risk at a given time. If anything, you have to diversify it over time, and that's difficult for the insurers to do. That's just one example, and Shanthi, I'm sure you've thought about that as well. So why don't you add on that as well?
Yeah, I mean, I think exactly what you're saying, that it's just a non-diversifiable risk and it's so large. And so that's sort of some of the criteria we think of as being like a difficult to insure risk.
Yeah. And I think what you're seeing, the revealed actions of the insurers, both in their past efforts to include this kind of risk to the extent that they've been able to, and certainly the movements you're seeing now to exclude it. Then also their the public policy efforts to adopt some kind of government public-private partnership as an acknowledgement or expression of the notion that the insurers don't think they can cover this, because insurers they want to cover risk, they want to provide coverage, that's their business, right? So they want to be in areas where they think they can that work effectively, and the fact that they're pushing in favor of these kind of TRIA type programs tells you something.
Ty, can I just jump in? I mean, one thing that I think that these things help us to think about is, maybe we need to expand our notion of what it means for something to be insurable. Because if by insurable we mean, can you price it in advance for a fixed benefit at the end, then I think the answer is no. But if by insurable, do we mean that we can spread the cost of that risk through mechanisms that assign people responsibility for paying for it in some measure of the risk, then I think we can, but we need some kind of some ex post method. And that's why essentially that's what the government, the government doesn't pre-fund TRIA. The government kicks in the money for TRIA after the fact when something happens. Thankfully, they haven't had to have, other than the one event. And then what they do, they get it from taxes. They assess people from taxes. And for terrorism, you might say it's fair to do that through general, revenue, because terrorism is really an attack on the country, and so citizens ought to pay the same way for that we pay for everything else. But that you could have some kind of pandemic method that would be that kind of assessment. It's just that you need the government to help to participate. And so I would say it's if by insurable we mean, can it be insurable with the government working with the private sector, then yes. But if by insurable we mean, could the private sector do it all by itself? I don't think that anyone thinks that it
yeah,
is.
no, I totally agree that if you sort of cabinet or you limit the role that the private sector needs to, the risk they need to bear, you've got some possibilities there. I'm definitely of the mind of let's try to take as much advantage of the insurance mechanism as possible, for this risk as well as other risks. So let's try to figure out how to make it work, and how far you can push it. And maybe I thought the TRIA program has been modified over time. So if we start with something, and then as we gain more experience, you can modify it and adapt it, and that seems like a reasonable model here.
There was a question in the chat about the losses from the riots that were sadly accompanied some of the Black Lives Matter protests that I strongly support. Not the riots, of course, no one supports that. And that is an area where it used to be, the insurance used to be provided through a public-private partnership, but the insurance industry gradually came to decide that it could bear that risk. Now, of course, it's, because riots are don't tend to be global, so there maybe are less concentrated, but that's a model for how we sort of start out to do something with maybe the government taking a bigger share, and then gradually, it maybe not entirely phasing out, but taking out a smaller share as we get the data and so forth.
Yeah,
Of course, that takes people who think that government can be a solution to something to be running our government, which I hope that's going to be the case. And that's as political as I'll get. I don't care what party they are, as long as you believe government has a role, we can work with you.
Yeah, I was just going to add, I do think that the public health aspect of this it sort of necessitates that the government needs to, or would be involved, just because they don't want a situation where businesses are staying open just for the income, and they'd rather they close and contain the spread. And so they do have that vested interest, and that kind of goes back to Lloyd's point about, well, what's the premium? Like, should they charge a premium? They have this sort of added benefit.
I was just going to add, turning back just on the sole insurance company question, I think it's possible to an extent if you do look at the sublimits. If a company says, okay, we'll write you a policy and it has a $50,000, pandemic sublimit, and then that's a mechanism where they can assess the risk and move forward. A kind of a strange analogy that has popped in my head on the aviation insurance, they talk about the loss of an airplane, and because we have very expensive jets and people making a lot of money and then flying all over the place, they'll put a time limit on it. And so yes, you're now covered because you can't use your private jet, but you only get 30 days of that, or 60 days, and then we're going to cut you off because now we can measure the risk and move on.
Yeah, and just a response to that, I think having those sublimits, I think that's a good idea from the how to sort of limit the risk. But then, from a social point of view, you want you want a lot of payout because you want to keep people employed, during these times. So you've got to weigh these, the private interest and the public interest in that whole process.
And I think just to note, and if we think about the insurers that already were offering some level of quote unquote communicable disease coverage or virus coverage, but pursuant to a very low sublimit, if you read that coverage, it's pretty narrow with respect to what the insurers, I think, would argue they intended to cover, which is if you end up with, for example, COVID on your property and you need to spend money to clean it up, and you need to shut down for 2 days to do that, then the insurers, I think, would argue that their, for example, communicable disease coverage will pay for the cleanup costs and the business interruption you suffer for those 2 days that you're shut down. But once it's cleaned up and you're open, then that coverage is done. And so those low limits make sense in that context of that very narrow coverage. And the question will be going forward, if quote unquote pandemic insurance or communicable disease insurance is being offered more broadly, whether it's going to be at that narrow level or it's going to be at the broader level of you are closed, not because you could identify specific incidents of COVID on your property, but instead to prevent it from spreading and creating greater danger. So it'll be in the words again, as far as what ultimately the insurance industry may be paying for, even though it is quote unquote insuring some level of pandemic.
We just received a question, I think, that is related to the point you're just making, and that is in a sublimit space, do you think that it may be a valued policy contract rather than an indemnity-based contract might be a potential solution to those types of issues?
Let me just clear, as by value policy, you mean something where if the event happens, you just get an amount, like a life insurance policy, as opposed to one where that's interesting. I mean, would certainly, I don't know, that's interesting. This is what, there's some of this index, like the things, the rain insurance that people are experimenting with in India, that sort of, you could even have it be parametric, right? You'd have, you could imagine it being that it would pay out to sort of everyone in a given region. That's interesting. I mean, yeah. I don't know, Lloyd, that's a Lloyd question.
No, the insurers they're on that. These different programs that I went through, like the business continuity protection plan. That's endorsed by the American Property Casualty Insurance Association, for example, it has a parametric trigger, so that instead of the traditional indemnity type of insurance, if there's a government shutdown of these industries, then the firms in that industry would get this certain payment, and it's just you're done. So no, you don't have to show what losses you have or anything like that. So there is a notion that with a huge, however, whatever, there's how many businesses are out there, a large number, 6 million or 30 million businesses. I guess 6 million businesses was employees is what I remember. How do you can't adjust that many claims if the whole economy shuts down. So let's think of a different way to, try to get benefits out, and that parametric idea is one out there. Yeah.
So another big picture question that's been posed, and I think this makes a lot of sense, but we have a lot of government programs. They seem to be sort of fighting always the last battle, right? So you think about TRIA, and now we have potentially PRIA. Is there any merit or value to tearing down all that infrastructure and saying, let's just have a government program for very low probability, high severity events and define sort of broadly what those could be, and instead of doing it piecemeal?
Yeah.
Sounds great.
That sounds good. Yeah, started just on the, I think makes me think of on the homeowner side, there was, proposals over the years to, instead of having to buy a homeowner's fire policy and a flood policy and an earthquake policy all separate, to have a where you buy them all together. And so big advantages to that. Then the insurers don't have to fight about what's covered or what's not covered. It's there's no it's all in one policy. And so there's a lot of good arguments for that. Those efforts haven't succeeded at the federal level to sort of adopt a framework that would allow that. And there's different reasons for that, I think. One is that you do worry about policies like that and cross subsidies between different parts of the U.S. and how that works, and the different kind of pricing and how those programs would work. And then also certain insurers and business interests have a good market, a good business in one part of the current industry, and you would disrupt that. So so there's been a lot of discussion on the personal side, homeowner side about that. That's a good question about on the business side, and can we do something similar to that? I'll just leave it at that.
Okay. Let me look through and try to find another one here.
I saw one that I thought was interesting. Someone asked the question that said, hey, unlike floods, pandemics, from your lips to God's ears, it's a 1 in 100 year event. Why should we worry about, why should we spend a lot of time and money on that? And what I would say about that is sort of two things. One, even a 1 in 100 year event is pretty bad in the history of civilization. But second, if what we're doing is setting up one of these programs like Lloyd is describing, where there's not a lot of private sector skin in the game, it's really a kind of assessment approach. Like it's only going to cost us money if it happens. So so it's cheap to set up the framework, and it just sort of, prearranges how we're going to pay for it if and when it happens. So it is, it strikes me as, a 1 in 100, if there's the political will, it's a great thing to set this up for, because it won't actually cost you anything if it doesn't happen. And if it does happen, that's what government's for. We have tax people, we spend money.
Yeah, we didn't have the framework, and the government already paid, whatever it is, 2 trillion, 4 trillion, whatever.
Yeah.
So if we can have some sort of framework in place, and yeah, just like Tom said, if we need the framework, we have it. If we don't need the framework, then it can sit there for 99 more years, fingers crossed.
Right. Yeah, no, if the events were truly that rare, why would you go through all the trouble? But I do think that there's, advantages of, having an insurance approach. So if you have some kind of premiums, then you get these risk mitigation credits you can get potentially, and incentivize companies to adopt protocols that are, that are best practices. So there's some, I think, effect that you can have in behavior through the market in doing that. And then also, after, it reminds me of like the FEMA programs after a presidential disaster. Congress, in order to get the big money to Puerto Rico or New York City after Sandy, Congress has to adopt, pass a bill that provides, in that case, the Department of Housing and Urban Development, the money to do community development block grants, and then the HUD has to issue the rules for that, and it takes a year, minimum for that to happen. And so now the PPP, I think, as Arthur said, that was done pretty quickly. Although I think from what I understand, I haven't looked at that myself, there were issues on the distribution of that and how efficient and effective that was. So, you do have those trade-offs of on the fly adopting a program versus having something more in place.
And I was going to jump in again, if that's okay. Also depends on how you look at it. Yes, COVID has been described as 1 in 100 years because you're looking back at the Spanish influenza of 1918. But as we talked about at the beginning, from the insurance point of view, all of the policy language and drafting and that sort of thing goes back to the SARS issue or pandemic, whatever word you want to call it, of 2006. So that's only 14 years ago. And insurance company having to kind of reinvent the wheel on that language. And we also, of course, had Ebola, which we thought looked like was going to be another pandemic issue in between SARS and today. So again, it just depends on sort of how you look at it.
Linda, I think you're on mute. Yeah.
Sorry. It also, I think, is interesting that back in 2006, the insurance industry was thinking about pandemic and created a whole exclusion for it. And that you have so many insurers so many years later who didn't include an exclusion in their policy that was clear that it was intended to apply to pandemic. And particularly when that industry, there are huge sections of insurance companies that provide first party coverage where the employees look into the future and figure out what risks are out there that could create exposure, and that we didn't have more explicit pandemic exclusions on policies coming into this, I think is pretty meaningful. And I think it undercuts the insurance industry's effort to take language that look like pandemic at all and then try to twist it into pandemic when this is something you'd have to assume they were already thinking about.
So we have a question here that's a little bit more specific, law related, but in terms of contract interpretation, is there any difference when a business has active and or widespread cases of COVID in their establishment, and how does that affect coverage, as opposed to those that are shut down because of preemptive public health restrictions?
I think from the law perspective, the argument that early on was debated was, is COVID on your property damage? And then that argument sort of moved on because a lot of businesses were shut down, even though there was no evidence of COVID actually having been on their property. If you can identify multiple instances of COVID on your property and shutting down specifically to address that or those incidents, then that is a stronger argument in favor of the property damage piece of the trigger as opposed to the loss of use piece. And so I do think you're making a different argument there. You're making that there is the argument that there is actual property damage on your at your premises, and therefore there should be a stronger basis for coverage under that section of the trigger.
You know, that brings up a point that I've been trying to get across through the blog and the project, which is that the presence of a virus exclusion makes it harder for someone to win on the physical loss of property damage part that Linda's talking about. So that's why the CCLT makes a big deal out of whether there's a virus exclusion or not when we interpret the fact that an insurance company won on a motion to dismiss, even if the specific reason they gave, the judge gave, had nothing to do with the virus exclusion. You know, as the judge, that many of the courts have said, hey, there's no physical loss or damage. Your pleading says that there was no virus at your place. Your pleading says that it never got near the property. So how could there possibly be property damage? Well, the reason the pleading never says that is because they have a virus exclusion, and they don't want to say that it was because of the virus exclusion that they closed the property. And so, so I think, pretty much everybody agrees with Linda that does strengthen your case. Whether it means you win or not, there's arguments against it and so forth, but that you're in a stronger case if you can do that. I mean, of course, if you're a restaurant, if you really want to go run around advertising, they had a lot of people with COVID in the restaurant, there's a different question.
But I do have one. I found one case site I was going to put. Is that so? Ty, logistically, would that go in the chat or in the Q&A?
So it would go in the chat, I believe.
Chat. All right, I might put it in both. But anyway, there was one. I found one case that I thought it was interesting. Yeah, just like they talked about, like Linda mentioned. Yeah, arguing that the physical particles of COVID in my insured property has now triggered the coverage because it's damage and it's a physical loss, whereas not having COVID on the premises, you have to refer to the civil authority and emergency orders and all that sort of thing. But it is an interesting distinction to try to walk through, and also can create a fact question, which at this early stage, motion to dismiss stage, you can come up with any fact questions as the policyholder that's helpful to move forward.
Great. Does anyone else have any responses or see a question that they are just dying to answer? I think we've hit most of them. Oh, I think we've hit all the Q&As, at least from a big picture perspective. There is 10 minutes remaining, and so I think what I'll do is turn it over to Eric Tempelis, who is going to do the concluding remarks for the Thompson Center.
Sure. Well, thank you everyone for joining us today. This has been a really fascinating discussion. As everyone knows, this is an issue that has been with us for months, and based on the litigation that's going on and the policy discussions that are going on, there are probably going to be legal and policy and business implications, including for consumers moving forward, that we'll have to all keep an eye on. I mean, none of this is happening without an effect on everybody. So with that said, I just wanted to go back and again, thank all of the co-sponsors, the UW Law School, the School of Business at UW Green Bay and at UW Milwaukee. Dick Marcus, I know, is with us today. I also want to thank Ty for giving his time today and his expertise in sort of moderating this session on behalf of the UW School of Business Department of Risk and Insurance. Their department has been extremely helpful as we've tried to put together a series of webinars on these sorts of issues. So we thank Ty and his department specifically as well. With respect to those who are pursuing CLEs today, you'll see the link that you'll have to input your codes into. The first code was given out earlier in the middle of the event today. The second part of the code that you'll have to enter in is DINNER, D-I-N-N-E-R. So please go ahead and do that. You'll probably need to do that by 4 p.m. today in order to get credit. So if you have any questions about that, you can email the Thompson Center to ask for more details. With respect to future events, we'll be bringing together another cohort of speakers on to whom should Wisconsinites look to advance digital privacy and security. It's on Friday, November 20th from noon to 2 p.m. Central Standard Time. We'll also have events coming up later in the spring. So we encourage you to go to the Thompson Center's website if you'd like to participate and attend those events. Again, thank you to all of our panelists today. Thank you to our co-sponsors and for everyone who joined us. Take care.